October 14th, 2025. Cedar Ridge Juvenile Court. 16-year-old Landon Mullen leaned back in his chair as though the seat had been arranged specifically for his comfort. One arm draped over the back, his chin tilted at the particular angle of a boy who has decided in advance that nothing happening around him is worth his full attention. He was wearing a gray button-down shirt his mother had pressed the night before, and his dark hair was clean and combed in a way that would not last past the first hour of proceedings. He looked around the courtroom the way a person looks around a waiting room, mildly, cataloging exits and faces and the position of the cameras with the absent attention of someone with better things to think about. For Landon, this was not justice. It was an act, and he was the lead. He had been grinning since the arraignment, not constantly, not with the fixed expression of someone working to maintain a performance, but intermittently, the easy surfacing grin of a yaya, boy who keeps rediscovering that the situation is less serious than everyone else seems to think. He grinned when the prosecutor spoke. He grinned when the detective testified. He had winked at someone in the gallery during a recess the previous week, a girl from his school who had not winked back, and he had registered this without changing his expression, filing it alongside the other things that were not going quite as he expected, while somehow not disturbing his fundamental certainty. Charged with involuntary manslaughter after what the defense had carefully and consistently termed a tragic accident at the abandoned Harlan Quarry, he treated every moment of the proceedings as a stage and every person in the room as an audience. He was 16 years old, and he was good-looking, and he had been popular since the 6th grade, and popularity had taught him that the room was always watching him, and that this watching was generally favorable, and he had not yet encountered a situation in which those assumptions did not hold. His best friend, Dex Pauley, was not in the courtroom. This was a fact that Landon had noted on the first day and filed under things that were fine because Dex was Dex, and Dex had been with him at the quarry, and Dex knew the story they had agreed on, and the story was not complicated, and Landon trusted Dex with a confidence so complete that it had not occurred to him to examine it. The truth was darker than the story. What Landon was certain of, sitting in that chair with his arm over the back and his chin at its chosen angle, was that no one could prove anything that mattered. There had been no witnesses except Dex. There had been no camera, except that he had not thought carefully enough about what Dex was doing with his phone in those minutes immediately after, when Landon had been talking, explaining, still buzzing with the specific intensity of what had just happened, the adrenaline and the surprise and the dark, complicated feeling of watching Tyler Marsh disappear over the edge of the Harlan Quarry ledge. He had not thought about Dex's phone because he had been thinking about himself, which was his consistent habit, and it was the habit that had, 47 seconds of screen time ago, ended his performance permanently. He did not know that yet. He grinned when the prosecutor spoke. Prosecutor Anita Walsh was 44 years old and had been trying cases in Ohio courts for 17 years, the last 8 of them in juvenile and young adult proceedings. She was a compact, focused woman who moved around the courtroom with the economy of someone who has learned not to waste effort on distance that does not serve a purpose. She had built her case over 8 months with the methodical patience that this particular case required, because the case had, in its initial form, the specific shape of a tragedy that could be called an accident. 2 teenage boys at an abandoned quarry, 1 fall, 1 survivor with a story of reaching and missing and shock and grief. She had not believed the story from the first reading of the incident report. The details were too clean. The emotional account Landon had given the responding officers was articulate in the wrong way, too organized, the sequence of events assembled in an order that was logical, rather than the fragmented, adrenaline-disordered order in which people actually recall terrible things they have just survived. She had filed this observation privately and proceeded with the evidence. The evidence had, over 8 months, accumulated in the direction she expected. The 12-minute gap between the estimated time of the fall and Landon's 911 call. The shoe analysis that found no scrape or dust patterns consistent with someone who had lunged forward to catch a falling person. The forensic physics of Tyler Marsh's trajectory, the angle and distance of impact suggesting forward force rather than a backward slip from an unstable edge. The text messages between Landon and Tyler in the hours before, Tyler's messages carrying the specific edge of a person who was about to confront someone about something serious. And then there was what Detective Marla Kent had found, which was not evidence in the technical sense, but which had the quality of a locked door that you know contains the room you need. The knowledge that Dex Pauley had been present at the quarry, a fact that Landon's initial statement had not mentioned, and that had emerged through the careful cross-referencing of phone location data, a fact that Landon had explained away when pressed as Dex had been down the hill and away from the ledge. He hadn't seen anything. He wasn't part of it. Detective Kent had interviewed Dex Pauley 3 times. The first interview, conducted the Monday following the incident with Dex's parents present and a juvenile advocate in the room, was standard in its structure and produced what standard first interviews with frightened teenagers typically produce: a version of the agreed story, delivered with the specific over-smoothness of someone who has rehearsed it. Dex had said he was down the hill when he heard Tyler fall. He had said he had not seen anything. He had said Landon had seemed in shock. He had said Tyler's fall was an accident. Kent had noted the over-smoothness. She had noted the specific moment during the interview when Dex's eyes went to a spot on the wall to the left of the table, which is where people's eyes often go when they are accessing a prepared statement rather than a genuine memory. She had noted the way his breathing changed when she asked about the period between the fall and the 911 call, a question she had asked 3 different times in 3 different phrasings, and each time Dex had given her the same response, word for word the same response, which is not how genuine memory works, but is how prepared answers work. She had ended the first interview without pressing. She had given Dex the information for the Victims Advocate program, and she had thanked him for coming in, and she had watched him leave with his parents, and she had sat in the interview room for a moment with the door closed and had thought about the wall that his eyes had found. The second interview, 6 weeks later, had been different in its preparation. Kent had spent the intervening time building a more complete picture of the timeline through phone location data and through interviews with other people who had been in the vicinity of the quarry area that afternoon. She had established with reasonable certainty that Dex Pauley had been significantly closer to the ledge than his account suggested, close enough that the sound of a fall would have been immediately audible. She had asked Dex in the second interview whether he and Landon had talked after the fall. Dex had said no, and something in his face had moved, a small shift in the muscles around his eyes that lasted less than a second, and was gone, and Kent had seen it and had filed it. The third interview had been the one that changed everything. Kent had sat across from Dex and had said, without preamble, "I think you recorded something on your phone after Tyler fell, and I think you still have it." She had said this in the tone of someone describing something already established, and she had watched Dex Pauley's face go through 4 expressions in 3 seconds: surprise, calculation, something that looked like relief, and then the specific expression of a person who has been carrying a secret for 6 weeks and who has just been offered a door. Dex had said, "I need to talk to my mom." His mother had arrived within the hour. The family's attorney arrived 30 minutes after that. The negotiation of Dex's cooperation, including the terms of his immunity from any accessory charges, took 2 additional days. And at the end of those 2 days, Dex had opened his phone and found the file that had been sitting there for 6 weeks, and he had handed the phone across the table. Detective Kent watched the 47 seconds in that conference room and did not allow her expression to change, which was an act of professional discipline that cost her something. Then she had thanked Dex and had taken the phone into evidence and had driven back to her office and called Anita Walsh. She had said, "I need you to come and see something." Anita Walsh had come that evening and had watched the 47 seconds and had been quiet for a long time. Then she had said, "How solid is the chain of custody?" Kent had said, "Complete. We send it to digital forensics for metadata authentication, and we have everything." Walsh had said, "Get me everything." She had. The case had changed shape entirely. Landon Mullen's arraignment had taken place on a Tuesday morning in August, and the courtroom had been half full, the normal attendance for a preliminary hearing in a case that had made the local news as a tragic accident and had not yet become anything else. Landon had arrived in his pressed shirt and had looked around with the proprietary expression he applied to most rooms, and had sat beside his court-appointed attorney, a man named Gregory Hess, who had been practicing juvenile defense for 11 years and who had met many clients in many states of mind, and who had formed, within the first 15 minutes of meeting Landon, a clear-eyed assessment of what the coming months were going to require from him. When the clerk read the charge, Landon chuckled. It was not a performed chuckle, not something calculated for effect, but an involuntary sound, the chuckle of someone who finds an absurd situation briefly funny before remembering where they are. He caught himself and assembled the more appropriate expression of serious attention, but the chuckle had been heard, and 3 reporters in the back row had written it down. He leaned toward Gregory Hess and said, at a volume sufficient for nearby gallery members to catch the general shape of the words, "This is insane." Gregory Hess had said nothing. The charge had been entered as involuntary manslaughter. The defense narrative, as Gregory Hess presented it in the preliminary hearing, was straightforward. 2 boys at the quarry on a Saturday afternoon, horseplay near the edge, an unstable section of ledge giving way, Tyler Marsh falling before Landon could reach him. A terrible accident, a traumatized survivor. A family in grief whose grief was real and whose need for answers was understandable, but whose certainty that something more than accident had occurred was not supported by the evidence. Gregory Hess believed approximately 40% of this narrative. He was a professional, and he presented 100% of it with conviction, because that was his job, and he did his job. But in the private accounting he kept throughout every case, the tally was not favorable. Prosecutor Anita Walsh's statement at EHT, the close of the arraignment, was 4 words, delivered without emphasis or drama. This was no accident. She sat down. The hearing concluded. In the corridor afterward, Landon told his mother that it was going fine. His mother, a woman named Sandra Mullen, who had been holding herself together with the specific effort of a parent who needs to believe their child and cannot fully manage it, had looked at her son and said, "Landon, you need to take this seriously." Landon had said, "Mom, I am." He had said it with the easy reassurance of someone who had spent 16 years managing his mother's concerns and who applied the same technique now without recognizing that this situation required something different. He was, even then, performing. The audience had changed, the stakes had changed, the technique had not. The trial formally opened on the first Monday of October and ran for 3 weeks. The Cedar Ridge Courthouse had not seen this level of coverage since a case 8 years previous that had involved a school board scandal and which had been, in the community's estimation, less personally painful than this. Tyler Marsh had been 16 years old and had played on the same soccer team as several of the jurors' children, and his death had landed in the community the way deaths of young people land, when the young person is specific and known and embedded in the daily life of a place, not as news, but as absence, a name that should still be said in the present tense and is now said in the past. His parents, Richard and Carol Marsh, sat in the first row every day. Richard Marsh was a tall man who had played college basketball and who now coached youth sports in the evenings and on weekends. And he sat in the front row of the courtroom with his large hands on his knees and a quality of stillness that was not calm, but its discipline, the stillness of a man who has organized his feelings into a structure that will hold for as long as required. Carol Marsh sat beside him and held in her left hand, on certain days, a small photograph of Tyler that she did not always look at, but that she carried as the thing you carry when you need to know it is still there. Landon saw them every day. He did not look at them more than briefly, and when he did look, he looked away before his expression could settle into anything specific. The smirk was present most of the time, available and easy. But he directed it elsewhere, toward the prosecution table, toward the gallery, toward the cameras that he had learned to locate in any room within the first few minutes of entering it. He had been told by Gregory Hess not to look at the cameras. He complied with this directive in the same way he complied with all of Gregory Hess's directives, which is to say, he followed it as a general policy while making specific exceptions when the situation seemed to call for them. He had mouthed the words, "This is stupid," at a camera during a recess on the fourth day. Gregory Hess had seen this on the evening news and had spoken to Landon about it the following morning. Landon had said, "I was bored." The first substantive evidence came through Detective Marla Kent, who took the stand on the third day of testimony and presented the forensic scene analysis with the unhurried, systematic delivery of someone who has organized a complex body of information and trusts that the organization will carry its own meaning if she presents it clearly. She was a methodical woman of 47 with steel-rimmed glasses and the quality of attention that belongs to people who have been looking carefully at things for a long time and have learned what looking carefully actually means. She described the quarry, the geography, the height of the ledge from which Tyler Marsh had fallen, the terrain below, the specific section of ledge that the defense had characterized as unstable. She described the forensic examination of Landon's shoes, which had been collected the evening of the incident. She described the absence of the specific scrape and dust transfer patterns that would be present on the shoes of someone who had lunged forward in an attempt to grab a falling person. She described what those patterns would look like if present, the specific characteristics of the scrape angle and the dust compression, and she described what was on Landon's shoes, which was none of those things. She described the 12-minute gap between the estimated time of the fall and the 911 call. She said the gap was not consistent with a person in shock who was trying to help someone or who had attempted to descend to where the person fell. She said it was consistent with a person who remained at the site of the incident for a period of time before calling for help. Gregory Hess cross-examined on the shoe analysis, establishing the limitations of the methodology, the variability in how physical evidence transfers, the possibility that Landon had been positioned differently than the prosecution was suggesting. Detective Kent engaged each challenge with the same measured precision she had brought to direct examination and held her conclusions. Hess sat down, having made legitimate points that would not, in the end, be sufficient. Landon, through Kent's testimony, had maintained the loose-limbed posture of disengagement, but something had shifted slightly in the quality of it. The arm over the back of the chair was present, but the angle of his chin had dropped by a few degrees from its usual position, and his eyes moved across the room with a slightly more active tracking than the blank survey they usually performed. Gregory Hess noticed this, and noted it without saying anything, because there was nothing useful to say at this point in the proceedings. The text messages came in the second week. The prosecution had obtained them through the digital discovery process, extracting them from Tyler Marsh's phone, which had been recovered at the quarry below. The ledge, the screen cracked, but the data recoverable. The messages showed an exchange between Tyler and Landon that had begun 3 days before the incident, and that had the specific escalating quality of a conversation where one person is approaching a confrontation they have decided to have, and the other person is managing it with the deflections of someone who does not want to be confronted. Tyler had been planning to tell the school administration about something Landon had done, a combination of cheating on a shared exam, and then telling a story about the cheating that implicated Tyler rather than himself, a story that had affected Tyler's academic standing in the honors program. The messages documented Tyler building toward this confrontation with a specific mixture of anger and something that read, in retrospect, and with terrible clarity, like the determination of a person who has decided to do the right thing and is making sure they do not lose their nerve. Tyler had written in one message, "I know what you told Mr. Donovan. That wasn't what happened, and you know it." Landon had replied, "I told him what I remembered. We both know things got confused." Tyler had written back, "Nothing got confused. You lied about me to cover yourself, and I'm not letting it go anymore." There had been a gap of several hours before Landon's next message, which read, "Fine, this is getting stupid. Can we just talk about it in person?" Tyler had written, "Fine, when?" Landon had written, "Saturday. Come to the quarry. We'll sort it out without anyone else making it a big thing." And Tyler had written in the last message he would ever send, "Okay, afternoon?" When Anita Walsh read these messages aloud in the courtroom, the word "okay" landed with a particular weight, the specific terrible weight of a last ordinary word that did not know it was the last, a word typed by a 16-year-old boy who was trying to resolve a problem fairly and who had agreeing to the circumstances of his own death. Landon, at the defense table, shook his head as the messages were read, the theatrical headshake of someone listening to a characterization they dispute. He had been told by Gregory Hess not to shake his head during evidence presentations. He did it anyway, a reflexive communication to the room that he was not accepting what was being said, that the room should note his non-acceptance. Several jurors noted his non-acceptance without it moving them in the direction he intended. Juror number 6, a woman named Phyllis who had taught middle school English for 28 years and who had watched a great many teenagers in the process of being teenagers and had developed precise instruments for reading them, wrote on her notepad, "Shakes head" at his own texts. She looked at what she had written and underlined it. Juror number 2, a man named Bernard who owned a hardware store and who had been skeptical of the prosecution's case in the early days of the trial, had changed his assessment significantly over the second week. It was not any single piece of evidence that had moved him, but the accumulation, the way the pieces fitted together in a direction that had no reasonable exit, the gap, the shoes, the trajectory, the texts. And now, watching Landon shake his head at texts that Tyler Marsh had sent from a phone recovered at the bottom of a quarry, Bernard had arrived at a place from which he would not be moving. He did not write anything in his notepad. He looked at the text on the screen, and then he looked at Landon, and then he looked at the screen again. Gregory Hess cross-examined the prosecution's phone forensics expert on the context of the messages, attempting to establish that arguments between teenagers about school matters were common and that the existence of a dispute did not establish murderous intent. The expert agreed that disputes were common. He held firm on the specifics of the message sequence and its timeline relative to the incident. Hess extracted a modest point about interpretation and sat down. Landon leaned toward him and said something. Hess did not respond. Outside the courtroom during the lunch recess that day, a reporter from the Cedar Ridge Gazette named Paulo caught Landon in the corridor for approximately 15 seconds before his escort redirected him. Paulo asked how he felt the morning was going. Landon said, loud enough for several bystanders to hear, "They're building a story out of texts. Teenagers argue. This is nothing." Paulo published this quote. It ran that evening under a headline about the case. By the following morning, it had been shared significantly on local social media, and the specific phrase "teenagers argue" had generated the specific kind of community response that accumulates when people who have been following a case feel that the defendant does not grasp the gravity of what is being said about him. Gregory Hess read the published quote and went to the courthouse early and sat in the conference room and waited for Landon to arrive, and then told him, with a directness he had been holding in reserve, that every word Landon said in or near this building was becoming evidence of who he was, and that the who he was becoming visible to the community was not helping him. Landon had said, I'm just being honest." Hess had looked at him for a long time. He had said, "That's the problem." He had meant several things by it, and Landon had understood none of them. The forensic physics testimony came in the third week and was the most technical portion of the evidence, presented by a specialist from the Ohio State Bureau of Investigation named Dr. Thomas Wren, who had spent 19 years applying physics and geometry to the reconstruction of incidents involving falls, impacts, and trajectories. He used a three-dimensional computer model of the quarry projected on the courtroom screen, and he walked the jury through the reconstruction of Tyler Marsh's trajectory from the ledge to the impact point below. He said the distance and direction of Tyler Marsh's landing point was inconsistent with a backward slip from the quarry edge, which would have produced a different trajectory, shorter and more vertical. He said the trajectory was consistent with forward force applied from behind, a push at an angle and velocity that his model could specify within a reasonable range. He was careful to say consistent with rather than proves, because he was a scientist, and consistent with was what the physics established. But consistent with was sufficient, because it was the third piece of evidence pointing in the same direction, alongside the shoe analysis and the timeline, and the jury had been watching all three accumulate. Gregory Hess cross-examined for 2 hours on the model's assumptions, the range of variables that could affect trajectory calculations, the possibility of a surface failure at the ledge edge, contributing to forward momentum. Dr. Wren acknowledged each variable professionally and explained why, given the specific parameters of the ledge and the fall, the variables did not materially alter his conclusions. The cross-examination produced no concessions that moved the needle in a direction the defense needed. Landon watched Dr. Wren's testimony with his grin in a reduced form, a version of it that was present but not fully committed. The grin of someone who has realized that the game is harder than expected, but has not yet admitted that the game might be unwinnable. He leaned toward Gregory Hess twice during the testimony and was redirected with a look each time. The announcement of the surprise witness came on a Wednesday afternoon at the close of the day's testimony. Anita Walsh stood and said that the prosecution would be calling an additional witness the following morning, an eyewitness whose testimony would require the prior day's expert evidence to be properly understood. Landon heard this, and his smirk reduced by a degree. He looked at Gregory Hess, who was looking at Anita Walsh with a professional expression that contained, in its very evenness, a specific kind of careful attention. Gregory Hess had known a surprise witness was possible. He had known, from the facts of the case and from the logic of the investigation, that the prosecution's confidence exceeded what the physical evidence alone could support, and that this excess confidence suggested they had something he had not yet seen. He had submitted discovery requests. He had received what he received. He had suspected there was more, and the announcement of the additional witness confirmed it without telling him what it was. He told Landon that evening in the conference room off the main corridor that a new witness was being called. He asked Landon if there was anyone whose testimony could hurt him, anyone who had been at the quarry, anyone who knew things that Landon had not told him. Landon said, "No. Dex wasn't near the ledge. He didn't see anything." Gregory Hess said, "Dex Pauley." Landon said, "Yeah." Hess said, "And you're certain he has nothing to offer the prosecution?" Landon said, "Positive?" Gregory Hess looked at his client for a moment. He said, "All right." He gathered his papers and went home and sat at his kitchen table and thought about what he was not being told and what tomorrow's session would reveal about the shape of what he was not being told. The following morning, Landon arrived at the courthouse in his gray shirt and looked around the room with his standard inventory. The courtroom was fuller than usual. Word had moved through the community, the specific way words move in small communities, and people who did not usually attend the sessions had arranged to be present. The gallery was nearly at capacity. Landon looked at the prosecution table, where Anita Walsh was setting up her materials with the focused efficiency she always brought to the morning. He looked at the gallery. He looked at the doors at the back of the courtroom, which were closed. Judge Sandra Okafor called the court to order. Judge Okafor was 53 years old, a former public defender who had been on the juvenile bench for 12 years and who had presided over cases involving young people in nearly every category of difficulty the law recognized. She was not given to theatrical moments or unnecessary speeches. She managed her courtroom with a precision that left no room for ambiguity, and that communicated through its consistent and unhurried authority that this court took its function seriously, regardless of how the defendant took it. She had been watching Landon Mullen throughout the proceedings with the same comprehensive attention she applied to all defendants, and she had formed certain assessments. She had not communicated these assessments. She would communicate them when the time came. Anita Walsh stood and said, "Your Honor, the prosecution calls its final witness. The state calls Dex Pauley." The courtroom doors at the back opened. Landon turned. Dex Pauley walked through the doors and down the center aisle. He was 16, the same age as Landon, with the specific kind of face that looks younger than its age, rounder and less composed. He was wearing a collared shirt, and he was walking with the gait of someone who is experiencing a physical sensation that is very close to fear, but that they have decided, through some act of will, to move through rather than around. He did not look at Landon. Landon's smirk did not disappear immediately. For the first 3 seconds after the doors opened, the smirk was present, the reflexive expression of someone who has encountered an unexpected event and has not yet processed its implications. Then Dex reached the front of the courtroom and took the stand, and the clerk administered the oath, and Dex said, in a voice that was audible and steady in the way of someone who has practiced being steady, "I do," and the smirk changed. It did not drop entirely. It became fixed, no longer a floating, surfacing expression, but something held in place by effort, the effort of a person who is not yet ready to let the room see what is happening underneath. Gregory Hess, beside Landon, became very still. Anita Walsh moved to the center of the room. She introduced Dex to the jury, established the friendship, the shared history, the presence at the quarry. She moved through this material with deliberate patience, laying the ground carefully before she brought in what she had come to bring. She said, "Dex, were you with Landon Mullen on the afternoon of September 7th? Dex said, "Yes." She said, "Were you present at the Harlan quarry?" He said, "Yes." She said, "Were you present when Tyler Marsh went over the ledge?" A pause. Then, "I was down the hill. I heard it." She said, "What did you do after you heard it?" Dex said, "I ran up. Landon was standing at the ledge. Tyler was—" He stopped. He started again. "Tyler was below." She said, "What did Landon do?" Dex said, "He said to call 911, but he said to wait a minute first." She said, "Did you wait?" Dex said, "Yes." She said, "What happened during that minute?" Dex looked at the table in front of him. Then he looked at Anita Walsh. He said, "He was talking. Landon was talking about what had happened, about Tyler. He was—" He stopped. She said, "He was what, Dex?" Dex said very quietly, "He was laughing." The gallery absorbed this. Several people in the gallery had been present at Tyler's memorial and had known Tyler, and the sound that moved through the room was the sound of people receiving a specific piece of information that they had suspected and had hoped was wrong. Anita Walsh said, "Dex, during this period, before you called 911, did you record anything on your phone?" A pause that lasted approximately 4 seconds, which is a long time, in a silent courtroom. Dex said, "Yes." She said, "Why did you record it?" Dex said, "I didn't plan to. I had my phone in my hand and I don't know. I think I needed something to be real." She said, "Has that recording been provided to the prosecution?" He said, "Yes." She said, "Has it been authenticated by the digital forensics expert who testified yesterday?" He said, "I was told it had been." She said, "Dex, "Thank you." She returned to her table. She looked at the court technician. She said, "Your Honor, the state moves to present Exhibit 42. Judge Okafor said, "Proceed." The lights in the courtroom did not dim, but the quality of attention in the room changed in a way that had the effect of dimming. The monitor at the front of the room, positioned where the jury and gallery and judge could all see it, came to life. The recording was 47 seconds long. The first thing visible was the quarry, recognizable from the photographs that had been entered into evidence over the preceding weeks. The ledge, the late afternoon light, the specific geography of the place. And then the camera moved, and Landon's face was in the frame. He was facing the camera, or nearly, his profile partially visible, and then full on as the phone's angle shifted. His face was flushed, and his eyes were bright, and he was laughing. His voice said, "He thought I was joking. I shoved him, and he just gone." In the background, Dex's voice, nervous and thin, said, "Dude, are you serious?" Landon's voice said, "Yeah, don't freak out." And then the recording ended. The courtroom was silent. The silence had a specific physical quality, the density of air in a room full of people who are not breathing normally, who are processing something that requires them to suspend the ordinary functions of being present in a room in order to absorb what they have just received. Carol Marsh made a sound. It was very soft, and it was the sound of a mother hearing the last thing she would ever want to hear described in her son's killer's own voice, described with a laughter, described as a thing that was casual and complete and already in the past tense. Landon Mullen's smirk froze. It did not drop. It froze, mid-expression, the specific arrest of a face whose performing mechanism has encountered something it does not have a response for. His color went in a matter of seconds, draining from his face in the visible, progressive way that color drains when the body is processing something the mind cannot yet reach. His hands, which had been loose on the table, gripped the table's edge. His throat moved in a visible swallow. He said, barely audible, to Gregory Hess or to the air or to no one, "Turn it off." The screen was already dark. The recording had ended. There was nothing to turn off. Gregory Hess had dropped his pen when the recording began and had not picked it up. The jury sat in their seats, and several of them were crying. Not dramatically, but with the quiet, uncontrolled tears of people who have been watching something build for 3 weeks and have now seen it arrive, who have been sitting with the fact of Tyler Marsh's death at the edge of their attention for all these sessions and have now been given, in 47 seconds, the specific human texture of that death, the voice and the laughter and the casualness. Phyllis, juror number 6, was not crying. She was looking at Landon Mullen with the direct, assessing attention of someone who has been reading people for 28 years and who is now completing an assessment she had begun on the first day of the trial. She looked at his frozen face, at the hands gripping the table, at the absence of everything that had occupied his expression for 3 weeks. She looked at what was underneath when the performance stopped, which was something younger and smaller and more frightened than anything Landon had permitted the room to see. She looked at it without sympathy. She looked at it as a fact. Judge Okafor allowed the silence to complete itself before she spoke. She had seen the recording in chambers the previous day, during the authentication review, and she had sat with it for a time before proceeding with her determination that it met the evidentiary standard for admission. She had not reacted to it in chambers with the reaction the courtroom was having now, because she had needed to be a judge reviewing evidence and not a person receiving it. But she had been both, privately, and what she had felt privately had settled in her and had shaped what she was going to say. She looked at Landon Mullen and said, "Mr. Mullen, stand up." He stood. His hands had released the table edge and were at his sides, and they were trembling at a frequency that was visible from the bench. He was not grinning. There was nothing on his face that could be called a grin. What was there was the face of a 16-year-old boy who has just heard his own voice confessed to killing someone and has heard it through 20 speakers in a room full of people who knew the person he killed. Judge Okafor said, "This court has sat with you for 3 weeks. It has observed your conduct throughout these proceedings with considerable attention. You have treated this process as theater. You have smirked at witnesses whose testimony concerned the last hours of Tyler Marsh's life. You have shaken your head at evidence. You have waved at cameras and rolled your eyes at the jury and used this courtroom as a stage for a performance that communicated, in every gesture, your belief that what is happening in this room does not touch you." She paused. "Exhibit 42 ended that performance," she said, "not because it surprised this court, which had the opportunity to review it in chambers, but because it surprised you. Your own voice surprised you in this room. The recording you made in the moments after Tyler Marsh went over the edge of that ledge. The recording you believed was private. The recording you believed would never be heard by anyone but the person who made it and the frightened friend you were performing for in those minutes, played in this courtroom through speakers that carried it to every corner and every person present." She looked at him steadily. "You laughed," she said. "You laughed in that recording. You laughed this morning in this courtroom during testimony because you had not yet heard what this court was about to hear, and your confidence that you would not be reached was so complete that you were still laughing. And then Exhibit 42 played, and you stopped, and what the courtroom saw when you stopped is what this court is addressing now." She let a moment of silence work. "Your own words proved what weeks of evidence had been building toward. He thought I was joking. I shoved him. Those are your words. You said them with laughter minutes after Tyler Marsh died. You said them to your friend while Tyler Marsh was below the ledge and you were above it. You said them before you called 911. You said them in the specific tone of a person who is pleased, not frightened, who is triumphant, not horrified, who has done something they intended to do and is relieved to have done it. Richard Marsh, in the front row, had his hands flat on his knees. He was looking at the front of the room. He was not crying. He was listening with the focused, complete attention of a man who has been waiting for these words for 8 months. Judge Okafor said, "This court has witnessed your theater. You laughed while a family mourned. You performed for cameras while a boy your age was buried. You arrived each morning with the posture of someone who expected to leave at the end of the day unchanged, and you spent each afternoon maintaining that posture through testimony that described what you did to Tyler Marsh in the language of physics and forensics and geography, testimony that you treated as an inconvenience." She leaned slightly forward. "What this court cannot treat as theater is the 47 seconds that revealed your character more completely than 3 weeks of observation. You are 16 years old. That age is a fact, and this court takes facts seriously. It does not mean you did not understand what you were doing. The text messages establish what was at stake. The 12-minute gap establishes the deliberateness of your response. The recording establishes your state of mind immediately afterward. These things together constitute not recklessness and not an accident, but a choice, made with the understanding of consequence that a 16-year-old who is planning a confrontation at a quarry edge possesses." She straightened. Tyler Marsh was 16 years old. He walked up to the quarry because he trusted that his friend was calling him there to talk. He was wrong about that, and the wrongness of it cost him everything. You used his trust as the mechanism. You used his willingness to come and sort it out as the opportunity. The forensic evidence establishes the angle of force. Your own voice establishes the intent. She looked at her notes briefly. Then she looked at Landon. "This case has been determined to meet the statutory standard for transfer to adult court. The gravity of the offense, the premeditation established by the evidence, and the specific nature of the act warrant this determination. You will be tried and sentenced as an adult." Landon said, "I didn't mean it like that." His voice was very quiet and had lost the performing certainty that had characterized it throughout the trial. It was the voice of a boy now, without the architecture of confidence he had been building around it for 3 weeks. Judge Okafor said, "You said what you meant on that recording. In the absence of any other account from you of what occurred at the Harlan Quarry Ledge, this court works with what you provided." What you provided was your own voice describing what happened as something you chose to do. This court is not in a position to substitute another interpretation. She paused. "I want to address something directly before I pronounce sentence," she said. "Throughout this trial, you have treated the grief of Tyler Marsh's family as background noise. You have sat in the same room as his parents for 3 weeks, and you have performed your confidence in front of them, and you have used this courtroom as a venue for demonstrating to yourself and to the cameras that you are not touched by what you are accused of. I have watched this. This court has watched this. The jury has watched this." She let that settle before continuing. The 47 seconds of Exhibit 42 are significant for 2 reasons. The first is evidentiary. Your words prove what happened. The second is what your words reveal about who you are when you believe no one is watching. You laughed, you were pleased, you described Tyler Marsh's death as something that had gone the way you expected, and the emotion in your voice was satisfaction. Not horror, not grief, not shock. Satisfaction. The courtroom was entirely still. "That recording is the truest evidence this court received," she said. "Not because it shows a crime, though it does, but because it shows the person who committed the crime as that person actually is, stripped of the performance you have maintained in this room. And the person in that recording is a 16-year-old boy who pushed his classmate off a ledge and found it satisfying, who laughed about it in the minutes that followed, and who then constructed a story and maintained it through months of investigation and weeks of trial with the specific confidence of someone who believes their intelligence is a sufficient shield against accountability." She looked at him directly. "It was not sufficient. Your best friend pressed record. The carrier preserved the metadata. The digital forensics team authenticated the file, and this court heard your voice say what you did and why and how you felt about it. Intelligence is not armor, Mr. Mullen. Arrogance does not excuse brutality." She looked at her sentencing determination. "This court will proceed to sentencing. The jury's verdict is guilty of second-degree murder based on the totality of the evidence. The sentence is 25 years to life to be served in adult correctional facilities." The gavel came down. The sound traveled through the courtroom the way sounds travel in rooms that have gone completely still, clearly and without echo, arriving everywhere at once. Landon Mullen stood beside Gregory Hess with his hands at his sides and his face the color it had been since the recording ended, drained and still and younger than it had looked at any point in the preceding weeks of performance. Tears came. They were not performed tears. They were the involuntary consequence of a body receiving news it cannot process in any other way, arriving without permission or design, the specific tears of a person who has been operating on certainty and has had the certainty taken from him so completely that the system that was holding everything together has simply stopped. He shook his head slowly. He did not say anything else. Richard Marsh stood when the gavel came down. He stood and he looked at his wife, and Carol Marsh stood beside him. They stood together in the front row while the room around them processed the verdict and the sentence and the specific sound of the word 25. And they stood together with the particular quality of people who have endured something over a very long time and who have now arrived at the place where the enduring becomes something slightly different, where the word forward becomes available again in a way it has not been for 8 months. Richard Marsh had a statement he had prepared for the victim impact portion of the sentencing. He delivered it in the voice of a man who is holding something very heavy and has decided to hold it carefully and completely. He said, "My son went to the quarry because Landon asked him to. Tyler trusted him. He trusted him with his time and his attention and his willingness to talk something through rather than letting it get worse. Landon asked him to come, and Tyler came, and Landon killed him for it. And then Landon laughed about my son's last breath. And then Landon came to this courtroom and laughed some more. He paused. He said, "He laughed about my son's last breath." He sat down. The courtroom was quiet for a long time after that. Dex Pauley had been escorted from the building after his testimony, before the verdict, in accordance with the arrangements that had been made for his protection and his transition through whatever came next. He had sat in an anteroom down the hall during the recording's playback and during the verdict and during the sentencing, and someone had come to tell him when it was done. He had sat for a long time after being told. Then he had said to the victim's advocate sitting with him, "Is Tyler's family okay?" She had said, "They will be." He had nodded. He had gathered his jacket and walked out to where his mother was waiting, and she had put her arm around him, and they had walked together to the car, and Dex Pauley had spent the drive home looking out the window at Cedar Ridge, which was ordinary and continuous and still there. And he had thought about the 47 seconds and whether he had done the right thing, and he had arrived at the same answer he had arrived at in Detective Kent's office and in the months in between, which was yes, and the yes was not comfortable, but it was solid, and solid was what he had. The abandoned Harlan Quarry was fenced and sealed the following spring after a lengthy legal process involving the property's ownership and the county's liability assessment. The fence was chain link and 8 feet tall, and it ran around the entire perimeter of the site. The ledge from which Tyler Marsh had fallen was still there on the other side of the fence, unchanged, indifferent to its history in the way that stone is indifferent to the things that happen near it. The fence was not indifferent. The fence said something, without words, that the community had needed to say since the previous September. Cedar Ridge High School held a memorial service for Tyler Marsh on the first anniversary of his death. His soccer coach spoke. Several of his teammates spoke. A girl named Rena, who had been in Tyler's AP biology class, spoke about the way he had laughed at his own puns, which were always bad and always delivered with the expression of someone who found them much funnier than anyone else did. And this specific detail landed in the gymnasium the way specific details land, with a precision that general eulogies cannot reach. Tyler's parents sat in the front row of the gymnasium as they had sat in the front row of the courtroom, together and contained, the discipline of public bearing maintained because it was required, and because maintaining it was itself a form of honoring the person they were there for. In the Cedar Ridge Juvenile Court building, in the clerk's archive, a file had been assembled and labeled, State of Ohio versus Landon Mullen. Inside it were the forensic reports, the text message logs, the shoe analysis documentation, the trajectory reconstruction materials, the digital authentication of Exhibit 42, the trial transcript, and the sentencing determination. And in the digital evidence archive, properly logged and secured, the 47 seconds that had ended the performance sat on a drive that was sealed and labeled and would remain exactly as it was for the duration of its retention requirement, which was longer than 25 years. The courtroom itself was empty by late afternoon on sentencing day. The cameras had been packed and carried out. The gallery. Chairs were being stacked by a facilities worker who was doing his job with the easy efficiency of someone doing something he has done many times, which is how all ordinary things are done in the aftermath of extraordinary ones. The defendant's chair sat at the defense table. There was no one in it. Landon Mullen had been led out through the back of the building in handcuffs, through the door that is not the camera door, into the vehicle that had been waiting, and the cameras that had been recording all morning had been recording the door he did not come through. And the story they had been following for 3 weeks had ended in the back of a van while the cameras aimed at an empty entrance and then packed themselves up and went to the next story. The empty chair at the defense table caught the afternoon light through the courtroom's high windows. The light moved across its surface and continued moving. The chair did not perform. The chair had no opinion about what had occurred in this room, or about the boy who had spent 3 weeks in it, grinning at cameras and rolling his eyes and building the performance of a person who expected to walk away, which was the performance of a person who did not understand what he was inside. What he had been inside was a room full of people looking at the truth, carefully and over a long time, waiting for it to become visible. And then 47 seconds had played through the speakers, and the truth had been visible. In his own voice, laughing, and the room had looked at it, and the gavel had come down, and the performance was over. The cameras had gone. The audience had gone. The chairs sat in the empty room with the dust motes moving in the late afternoon light, and whatever the room had held for 3 weeks had settled, as things settle after a long time of holding, into the specific quiet that follows when justice, imperfect and procedural and human, has done the work it exists to do. The case was cited in the following year's Ohio Juvenile Court Reform debate, specifically in the discussion around standards for adult transfer in cases involving premeditation. Attorneys on both sides of the debate cited it for different reasons and with different emphases, and the 47 seconds of Exhibit 42 were described in the legal record as among the most consequential pieces of self-recorded evidence admitted in a juvenile proceeding in the state's recent history. Carol Marsh, in the months following the sentencing, returned to the work she had been doing before September, which was teaching piano to children in the neighborhood. She returned to it slowly and not without difficulty, but she returned to it because the children came on Tuesdays and Thursdays and they needed her to be there. And being there for them was a thing she could do that was not about grief. That was about music and patience and the small particular progress of a child learning something new. She had told a friend, the Yamarons, previous spring, that teaching was the thing that was putting her back together, that the concentration it required left no room for anything else, and that sometimes no room was what you needed. Richard Marsh continued coaching. He stood on the sideline of a soccer field on Saturday mornings and watched children run, and he did what coaches do, which is pay attention and offer instruction and maintain the specific patience that comes from genuinely wanting someone to improve. He wore a cap with the Cedar Ridge Rec Department logo on it, and he carried a clipboard, and he was known among the parents of the children on his team as the coach who remembered everybody's name and who made the less confident players feel capable. Tyler's name was on the wall of the Cedar Ridge High School gymnasium in the memorial section, alongside the photograph from the previous year's team portrait, in which he was grinning the specific grin of someone who has just said something that made the person next to him laugh. It was a good photograph, and it told the truth about him, which is the best that a photograph can do. In the adult correctional facility where Landon Mullen was transferred following sentencing, a 16-year-old boy began the process of learning what 25 years means from the inside, which is a different education from any he had previously pursued, and one for which his performed confidence was entirely without use. He would have time. He would have, if he lived to serve the full sentence and was not paroled before its end, more time than he had yet been alive. What he did with it was a question that would not be answered for a long time and might not be answered in any way that satisfied anyone, and was entirely his to work out in the specific solitude of consequences that do not perform and do not applaud and do not move on to the next story. The defendant's chair at the defense table in Cedar Ridge Juvenile Court sat empty at the end of the day. The cameras were gone. The gallery was empty. The afternoon light moved across the floor at its angle, and the ventilation ran, and the clock on the wall ticked the seconds forward in the direction they always moved, without any interest in who had been sitting in the room, or what they had believed about themselves, or whether the performance they had been giving had been convincing to anyone at all. Anita Walsh drove home that evening and ate dinner and called her mother, as she did most evenings after a significant case concluded. Her mother asked how she was feeling. Walsh said she was tired and that she thought the right thing had happened. Her mother said that was enough, and Walsh had agreed that it was, and they had talked about other things for a while before saying good night. Detective Kent filed her final case report and placed it in the closed file and carried the file to the archive. She did not think about Landon Mullen. She thought about Dex Pauley briefly and about what it had cost him to hand over the phone and about what it said about him that he had done it. And she thought that this was the part of the work that was hardest to account for in reports and closing files. The part where an ordinary frightened 16-year-old chose to tell the truth when the easier thing was available, and he took the harder thing instead. She filed the report. She went home. The case was closed.